so we've covered all of Unit 4, Area of Study 1. As you notice, we're taking a bit longer to go for that area of study because it's the one that you're doing at the moment. So you want the detailed explanations there, and we'll go a bit faster in Unit 4 and Area of Study 2 and look at a bit less content, so in less detail to make sure that you guys can understand everything. But something you'll notice, and this is amazing for you because when you go back to school, this is what you'll be working with, that there are way less dot points for Unit 4 Area of Study 2. You will very, very quickly skim through this area of study, and before you know it, it will be exam preparation time leading up to your exams. It will go by really quick, Unit 4. Um, and yeah, so you can see some additional things that you need to know about. We'll talk about most of these dot points there, and including law reform. However, some additional research that you will have to study up on and you will be assessed on individually as well is um, one recent example of the Victorian Law Reform Commission recommending law reform. So we'll look at the VLRC in a broad way, but you will actually have to have a recent recommendation of the VLRC and be able to discuss it and evaluate it, um, and give examples of what it was about. Um, Similarly, um, you need the role of one parliamentary committee or one royal commission, and this is where the study design allows you to choose whether you want to study roles of parliamentary committees or royal commissions. So you actually get to choose. I personally studied royal commissions, and I found it was more interesting to me than parliamentary committees. But it probably will depend on what your school has decided. I do know royal commissions to be a bit more common and popular. Um, so therefore, you will choose which roles you study, either the parliamentary committees or royal commissions, and you will have to give a recent example of a recommendation, either by a parliamentary committee or a royal commission. So again, you will choose. You will only study royal commissions or parliamentary committee and give a recent example for only one of them. So if you get a question on the exam, it will tell you that you can use parliamentary committees or royal commissions as examples, and you will focus on one. So this reminds you of all the reforms, recent and recommended, you had to do for Unit 3. The journey continues, just like how you need to know about reforms, you need to know about reform recommendations, because basically these are what they are. Um, so that will take you to the end of the year. And the key skills, again, remember that you can use them to write up questions for yourself, and they are very, very useful. They tell you what you will be assessed on, what types of questions. So we're going to look at a lot of these concepts through a broad lens. We'll start by talking about the factors that affect Parliament in lawmaking. And these are the roles of the Houses of Parliament. And nothing new, we looked at the roles. The representative nature of Parliament, political pressures, and restrictions on the lawmaking powers of Parliament. So these are the four key things you need to remember, and we'll go into a bit more detail about each. So the first point, the roles of the Houses of Parliament. We already looked at them at the beginning of the slides if you want to rewind, but consider the effectiveness of the lower house in the circumstances where we do form a majority government. We know that that is beneficial. That is going to increase how much Parliament can make laws until the next election. If we have a majority government, they can quickly, bring up bills and pass them through and vote for them and easily make them become law. But if we have a hung parliament where there's no majority government, no majority party in the lower house, we know that law passing will be very, very slow, because the party that still has the majority of seats, they will have to get the support of other parties in order for their laws to pass through and become acts. Similarly, um, we also need to consider the effectiveness of the upper house. And there are two structures that we have also studied, that we need to know of here. The rubber stamp Senate, that remember just gives its stamp of approval to every piece of legislation. Very good for Parliament's lawmaking. They will get lots and lots of laws passed. So it enhances their lawmaking power. And this is where we said Senate has a very similar composition to the lower house. meaning the government party is also has a large number of seats in the Senate. And then the hostile upper house, which is what we usually have, where the composition of the Senate is very different. Laws will not get passed through quickly. When they reach the Senate, senators will ask for amendments or may just disagree with certain laws that the government is trying to pass, therefore decreasing Parliament's lawmaking power. Of course, there are good things and bad things that come from this. We probably want to decrease their lawmaking power a little bit, right? Such as with the hostile upper house, where they can still pass laws effectively and everything is good. We don't want to decrease them too much, like a hung parliament, because it might not even laws might not even get through the first house, and we will not have legislation coming through when we need it. And next, looking at the representative nature of parliament. So we know that Parliament, we have representative government. They are intended, especially the lower house, to reflect the views of the majority because they are the people who have voted them in, thus directly chosen by the people. And there are regular elections that ensure that Parliament remains representative, said House of Reps every 3 years. So the fact that they're directly chosen by the people and the fact that there is regular elections aims to ensure that Parliament remains representative and they reflect the interests of the people in their lawmaking. But there are some limitations with regards to this, including popular laws, reluctancy, and difficulty in predicting the future. What is start with the easiest reluctancy? Parliament may be reluctant or hesitant to make laws if they are controversial. Even if a large group of the population want those laws, it will cause controversy with other groups and it can affect their votes, so they might not be passing laws that are controversial. There are also, with regards to popular laws, laws that are popular with many groups will likely get passed on very quickly by Parliament and they will try to enact them into legislation. However, these can disadvantage minority groups and other groups that are not supporting the laws very significantly. And we have difficulty in predicting the future, kind of self explanatory. We don't know what kind of laws we're going to need. Parliament may not be able to make very effective, very relevant laws all the time because circumstances often change. And it's difficult to keep laws effective and up to date. So not going into these in too much detail, but these are kind of key points on these slides that you will actually look at in Unit 4, Area of Study 2. Next, we have political pressures, and this is a very fun one because it's really simple. What are the pressures that Parliament has? And you have domestic, internal, and international that you need to be able to define. Domestic pressures in Australia. So people like individuals, organizations, or businesses could be placing pressure on politicians or parties to implement law and support law reform that suits them. That is what they want, especially if they're large corporations that have a lot of money and a lot of power. This might be a significant amount of pressure. Internal pressures are where the members of parliament themselves are feeling pressure to vote along party lines, even if they don't agree with what their party is proposing. And this is very true because we often see all members vote along their party lines. And then, of course, international pressures, where other countries or international organizations, or even the pressure of things like treaties or declarations, could be putting on pressure on the politicians or government. And then we have restrictions on the lawmaking powers of Parliament. We know about all this stuff already. Well, we haven't really looked at specific constitutional prohibitions, but we have division of powers, so ensuring that powers are divided between the Commonwealth and the states, and the Commonwealth can't legislate everywhere, and states retain the majority of legislative powers, still the majority of areas. You will also study specific constitutional prohibitions, what is not allowed specifically by the Constitution because it is in the Constitution, and challenging the law ultra vires. So people withstanding being able to, or even a state, challenge a law of the Commonwealth, and the High Court can declare it invalid or beyond the powers of the Commonwealth Parliament. Amazing. Hopefully that makes a lot of sense. This is a really good summary if you guys download the slides and or have access to the slides and keep them handy, this is a really good summary that when you do go into more in depth, you can use as your summary, like revision notes and things. And okay, so the next dot point that we'll have a look at is the role of the courts. We know that this is to hear cases and resolve disputes. We've already kind of established this already, but going into more detail, need to understand that judges sometimes are making law because they're deciding cases. This is common law. This is what I talked about, judge-made law, through determining disputes and imposing decisions. So you need to be able to define common law and define when common law is essentially made. When does it happen? If the court resolves a dispute where there is no existing law, there is no applicable law, so essentially they decide what the best principle to apply could be, and they might be using persuasive precedent, which refers to decisions in other countries or other jurisdictions, so maybe from a different state, that have been applied to similar cases. They might draw on those to decide, okay, I see what happened in England. Maybe if you remember the snail, the Donaghy versus Stevenson case, that's an example of where we could use persuasive precedent for negligence. If you studied that in year 11, it's where there's no existing law. They often do take into account persuasive precedents from other court hierarchies where circumstances were similar, essentially what decisions were then made in that case. And they can also interpret statutes, so our acts or our laws, to apply them to the case before the court. So they can do the same thing that they can do with the Constitution. They can see what is implied within the law, even though it's not actually clear what the decision should be. They can see what was implied and determine that, and then create an outcome, such as with our implied right to freedom of political communication. And when a decision is made in the above circumstances, this establishes a precedent. So in this area of study, you need to know about precedent and the doctrine of precedent. And it is a very heavy, very important subject. It is a really important section of our common law system. It allows for judge-made law to actually operate and be effective. And it allows for consistency and clarity in how cases will be decided based on how prior cases and similar facts were decided by previous judges. So, when a dispute comes before a court, the court will first look to see if there were previous cases that dealt with similar facts and apply the precedent established in these. So, who has to follow the doctrine of precedent? All judges in all the courts that are lower than the court in which the initial precedent was established, where there is a similar set of circumstances. So, for example, say the Supreme Court establishes a precedent around some law that was vague, and they expanded that. And then the county court gets a case that is similar, and same issue. It's not really clearly stated in the law. We don't know how to interpret it. But then they know that the Supreme Court had a similar dispute, and they made some kind of decision in that case. And that case is very similar to the case that has come up for them. It involves interpreting the same type of legal principle. So, because they are a lower court, they have to follow the precedent. They cannot make a decision different to the one that was made in the Supreme Court. However, if the case went to the Supreme Court again, or a higher court of a similar nature, those courts that are higher in the hierarchy or at the same level, they are actually able to alter the precedent and alter that interpretation. And then that new interpretation will apply to all the cases with similar facts and circumstances and whatever needs to be interpreted in all the lower courts. So if a precedent is established in the high courts, for instance, it will apply to all of the court levels, all of the levels of the courts, except the high court. The high court will still be able to change the principle if another case comes along requiring a similar interpretation. So that's the breakdown of precedent. And as you can see, of course, that allows for consistency and clarity, What is the purpose of precedent? Similar cases will be resolved in a similar way, ensuring consistency, ensuring clarity, ensuring fairness for everyone. So when it comes to the doctrine of precedent, there are key terms that you need to know of. Not just the doctrine of precedent, you need to be able to define that as well. And hopefully it's clear how to define that. It's that principle that um, cases will be decided in a consistent and similar way based on cases in previous decision, based on previous decisions in previous cases by previous judges. Um, so what are some key terms? We need to know about ratio decidendi. This is the Latin term for meaning the reason for the decision. It refers to the reasons why the judge made a certain decision in a case, and it is the binding precedent. So all the lower courts will have to follow the reason for the decision, meaning they will have to impose the same decision and refer to the reasons for why that was the decision in future cases. Only courts on the same level of the hierarchy or higher than that court will be able to change this. Obiter dictum refers to, literally means by the way, and obiter dicta is the plural form. These are statements that are made by judges on points of law. So these are comments that judges will make with regards to a case. And it might be saying something like, oh, I am a lower court, but I really disagree with this ratio decidendi. I have no choice but to impose it, but here's why I disagree and why I think it should be this principle. It might change something, it might not change something. Or it could even be, say, with regards to criminal law, commenting that they think for this person it's not fair that the judge has to impose some kind of sanction based on law. So these are comments made by the way. This is how you can easily remember this term. They do not have any actual influence. They are quite literally just comments that the judge makes. So they do not form part of the ratio decidendi, and they are not binding precedent. But if, say, a judge decides to listen to one of these comments and they're in a quite high position, they might decide to change a principle if they have the opportunity to do so. So it can have some influence. Um, and then we have stare decisis, which means stand by what has been decided, which is literally the doctrine of precedent, the process that I explained to you, where we have to follow similar decisions for similar cases to ensure consistency. So this might seem like a lot, but it's hopefully you find it relatively easy or interesting to talk about this. Um, Next, we'll have a chat about the reasons for statutory interpretation. So there's several things here, but why do we interpret acts or law? Why do judges do this? So there might be problems that occur during drafting. So when the law is actually being made, when the act is being written, this could include mistakes, and this could include if future circumstances and changes in how society would change and values would change if that wasn't taken into account. If the law is not clearly expressed or clearly defined, it might be some inconsistent use of wording that's creating issues, or not covering new technology that has come out. It even gets its own dot point because it's a really significant thing in the 21st century. So all of these are self-explanatory, but you want to give examples for yourself, and you will have questions where you will have to give examples of what a mistake would look like. You can choose what kind of example you want to give, but explain questions where, if, for example, if I chose that it doesn't take future circumstances into account, I might need to explain with an example. This is also really good because although these points are really easy, it's difficult to remember all of them, and you need to. So you want to give yourself examples anyway, so that you can make a connection in your mind and remember them, and be able to answer the questions. There might be problems also that occur during the application. So we have the act and we're trying to apply the law, but there is a problem that's arising from this. For example, and we see this with all the stuff with regards to the Constitution, too broad. Not sure what it means. So a judge needs to define what exactly that law, that statute was intending to mean, and all the things that do apply and other things that fall outside of that law. It may be out of date, so already future circumstances have happened, and now it's difficult to apply a law because it is so outdated. Words could be ambiguous or have contradictory meanings. Ambiguous meaning unclear, or they might be contradicting each other. This is very very difficult, especially if there's contradictory meanings, and the statute literally contradicts itself. And acts might have gaps which the court literally needs to fill. So it doesn't take into account all circumstances that the law may apply in, not giving a solution for each type of circumstance. And also, meanings of words can, of course, change over time, and that is natural. So you will be looking at some cases and having to give a few examples of some cases that showcase some effects of statutory interpretation, which will be very interesting. Um, so the effects of statutory interpretation, it obviously develops a new precedent. Um, if we are expanding upon the words that are in the act or defining things or adding to it, it will develop a new precedent in a lot of cases. And or words or phrases in the acts are given meaning. So if they are ambiguous or unclear, contradicting meanings, out of date, they are defined again by judges. And also, of course, the scope of legislation can be restricted or expanded. So we might have a judge, and we'll talk about this soon as well. A judge that is a judicial activist, and he wants to expand the rights that fall under the law. So if he says, oh, okay, this doesn't say which technology the Commonwealth can legislate around, but I think this is really broad, so I'll expand it to practically all types of technology. Now I've just expanded the now I've just restricted the Commonwealth's ability to legislate, but I've expanded like uh, the people's rights around it, and or expanded the state's powers to legislate around that area. So inevitably, it's either going to restrict or expand practically every time, because by doing an interpretation, it's going to have that effect inevitably, either expanding how the law operates or decreasing its operation. So you might even get questions where you have to interpret which of these would be relevant. Either way, you need to remember all three effects. Um, and next, we'll look at the factors that affect courts in lawmaking. So this will make a lot more sense. It will make it easier for you to make sense of what we just looked at before. So we'll look at the doctrine of precedent, judicial conservatism, activism, cost, and requirement for standing. A lot of this is very easy, knowing that we've already discussed doctrine of precedent, we've already discussed cost, we've already discussed the requirement for standing. So it's not too many new terms here. So the doctrine of precedent, we've defined it and discussed it. How does it affect courts and lawmaking? For all of these 5 points, you will need to also be able to answer evaluate questions. So some strengths of the doctrine of precedent, of course, it ensures consistency and fairness, because it's ensuring that all cases that are similar or the same, they are treated in the same way. Everyone should know or be aware of what the outcome will be for them if taking something to court, if there is a common law precedent that is already in operation. Also, by looking at past cases, litigants therefore can judge how their case is likely to be decided. They can decide not to take it to court or take it to court based on the information that they have. And courts can develop law where Parliament has not yet created statutes. So we said if there is no pre-existing law, the courts can literally develop common law principles in that area and develop a doctrine of precedent in that area. What will Parliament probably do in response is they'll see that this has happened, and they will choose to legislate quite quickly, because there's a gap in the law that has been discovered through a court case. So if Parliament does legislate in this area where a precedent was developed but there's no existing law, they might still legislate similarly to the court's decision, or they might choose to do something completely different and legislate against the court's decision. If that were the case, then of course the Commonwealth or the state law is taking priority over the court's decision. So in that case, if there are future cases with the same problem, the courts will now have to use the laws that the parliament has now created, and they cannot use that precedent that they developed anymore. And then what are some weaknesses? So it can be inefficient because in order to change the law and keep it updated, the litigants have to bring a case before the court. Um, so this is not an efficient process because, again, courts are not proactive, they are reactive. Someone needs to bring cases. They cannot actively fill in gaps in the law, or and there are lots of those, or interpret statutes, and they have to wait for someone with standing and being able to afford it. It is also difficult to know when a judge may decide to distinguish a case, and this is where the judge will essentially say, this case is different. It has different circumstances, slightly or a lot, to the circumstances in which the doctrine of precedent was developed for that case. So a judge can still be able to develop new common law if they say that the facts of this case are too different from the one in which the principle you want me to use was established. And that can happen. And it's quite, it's quite difficult to determine if the differences in my circumstances are enough to prompt them to say that, I can't actually, apply that. I have to interpret everything fresh. And another weakness is that this is dependent on cases coming before the court, which is expensive and time consuming. And that relates to the first point there. So next we'll have a look at factors that affect courts in lawmaking. So this is judicial conservatism and activism, two very easy terms. Students love this. They're pretty much opposites of each other. Conservatism, as it sounds, it relates to the idea that judges should demonstrate caution when making decisions and rulings that could lead to significant law changes. Hence, they should be more hesitant in ever expanding laws or making broad interpretations, and they should stick to the most conservative approach. So they try to maintain stability and leave the lawmaking to Parliament. They believe that lawmaking is the responsibility of Parliament and not their own. Therefore, conservative judges will often make the most limiting decisions and try to get Parliament to legislate. They will be hesitant to make any real change. It restricts the ability of courts to consider social or political factors or to be proactive in changing the law. They try not to change the law where they can, and they're not very good at taking into account societal factors. Judicial activism is the opposite. These are our proactive judges. The idea that the courts or judges should consider a variety of social and political factors when interpreting acts and deciding cases. So it allows them to recognize the rights of people and community views and make more fair judgments. They will change laws and they will try to consider all the circumstances and be proactive in changing the law. It can also lead to more appeals, however, and lead to radical changes that don't sit well with the community. The parliament may also have to interfere and change laws to remove some of these decisions. Um, yeah, you see that how in green and in red is your strengths and weaknesses, because remember, we need to be able to evaluate for these. So judicial activism is of course way better because we need laws to keep up with the time. Parliament isn't going to do everything for us. We need common law and doctrine of precedent to be developed as well. Even if we can have some appeals and some dissatisfaction, this is of course better than not doing anything and things remaining the same over time. So next we have the cost of bringing case to court. So of course, taking a case to court can be very expensive, and this can prevent individuals, or they may not even be able to afford such costs, and they couldn't qualify for legal aid. We know that legal aid, you need to have very low income. Income merits test is very difficult to meet, and for civil cases, not much support at all. Mainly focus on criminal. So remembering that courts can only make law on cases that come before them. We've already discussed that in this session. So of course, some strengths are that the cost can discourage frivolous or unbased claims, just trying to go to court just because you can. A lot of people might get upset about something small and say, I'll take you to court. But no, they won't because it's expensive. So this prevents backlog for the courts and makes sure that only claims that should be heard really come to courts, hopefully, for the most part. And it can encourage parties to use alternative methods or other institutions as well. There's no reason to overload the courts if the matter is simple enough and it can be resolved through alternative dispute resolution. We do want to encourage that by raising the costs of the courts so that people are more likely to seek out other avenues. Some weaknesses, costs can deter the litigants, so people trying to pursue claims who cannot afford such costs from pursuing their case or rights in the court. And then we can't have statutory interpretation because the case doesn't come. And then we have someone who has, say, suffered a breach of civil rights and they're not doing anything about it and it's not corrected. It can also deter parties from pursuing the appeal process, very costly, and even cost money to file a claim for an appeal, not knowing if it's going to be approved or not. And decisions in that case cannot be corrected. Not very fair. Um, and then we have our requirement for standing that we've also discussed in some detail today. This is referring to the idea that the litigant has to be directly affected by the issues involved in the case for the court to be able to hear the case. Very self explanatory. We're making sure that cases only go to court if people are genuinely affected by an issue and it needs to be fixed because it has affected them and it needs to be resolved for that reason, not just anyone that wants to bring a case for some kind of personal reasons or advocacy. It makes sure that people not directly affected have to seek other avenues, such as lobbying parliament, petitions, demonstrations, which we'll have a look at. And people who have a general interest in a case are unfortunately disadvantaged because they can't pursue the case because they don't have standing. And there could have been lots of potential improvements and smart decisions to laws that could have been made by listening to people with just intellectual interest in the case. This is lost because they don't have standing and they're not able to contribute to that discussion. Another difficult concept we'll go through. So the relationship between courts and parliament, um, how they influence each other. Supremacy of parliament, it's very straightforward. Parliament is the supreme lawmaking body. Courts ways of influencing parliament. Statutory interpretation, another way that courts influence parliament, and codification and abrogation of common law, which is done by parliament. So with regards to the supremacy of Parliament, it's important to understand, as I mentioned, that Parliament is the supreme lawmaking body. They're able to change and make laws as they please as long as it's within their constitutional power. Therefore, as I established that they can, as I already established that they can legislate to confirm or override, essentially make invalid court decisions with their laws as long as it's within their power. They can also even pass legislation to change the jurisdiction of the courts. As long as they stick to what's in the Constitution, that courts have to be separate and independent, they can still change their jurisdiction, though. So, all the ways in which they can influence the courts in a negative way, limiting their powers. Now, how about the courts? How do they limit Parliament, influence Parliament? Um, they can make comments when handing down judgments or obiter dicta comments. The Parliament might listen to this, and the judge might be saying, actually, there's no existing law in this area. You should create some laws in this area. Parliament may listen and create a law in that area with regards to the case. And they may make comments when handing down a statement or a obiter dictum. So this is referring to that. Comments. And these are opinions or statements that don't affect the outcome or judgment of the case, but they can try to incite some change. So key concepts, just obiter dicta under how courts influence Parliament for now. And Parliament as the supreme lawmaking body, being able to override courts' decisions and doctrine of precedent. Next, we have statutory interpretation. Of course, courts are responsible for applying the law, and therefore applying acts or statutes is very important. So, courts, as we discussed, can interpret Parliament law, and being able to clarify words, phrases, legislation, expand or limit the scope of legislation. So they can quite literally change the operation of Parliament's law, making it broader or more narrow, depending on the wording that Parliament has chosen. And then, of course, if this affects Parliament in a negative manner, they will have to legislate again and try to change that and be more consistent and be more clear next time. But they can literally affect the operation of laws as long as a case comes before them. Then, of course, we've got codification and abrogation of common law. So, codifying is where Parliament passes laws that confirm precedents set by courts and they become part of legislation. So, a common law decision, Parliament agreed with it, there was no law existing in that area, they decide to pass a law that follows on from the principle that the courts made in that case. Therefore, in establishing that doctrine of precedent, making it part of legislation, showing support for the legal principle. So, of course, abrogation will be the opposite, where they pass legislation that overrides or removes or abrogates a precedent set by a court because they disagree with it. The only exception is they cannot do this for high court decisions based on constitutional issues because that is within the high court's jurisdiction. Next, we have reasons for law reform. Why should laws change? There might be changes in societal values or attitudes, changes to social, economic, and political conditions, significant events, and a greater need for protection, or changes in technology. So we won't have additional information on it, but just think about how if values change and people's attitudes change, some laws will become inappropriate or consider that they should be updated to keep up with the changes. Of course, social, economic, and political conditions, just consider, for instance, for example, how inflation and the cost of living crisis should be dictating a change in law reform, some law reform, but it's not really happening. But that's a great example. And significant events and greater need for protection. So might even be worldwide events of, say, terrorism and awful crimes that lead to a perceived greater need for protection, and then that goes and becomes part of legislation. Changes in technology is a constant reason as well, with lots more technology emerging and needing to be controlled. Just consider AI. We need more laws to make sure it doesn't get out of hand, and there's no legislation, not enough legislation around it, so it therefore needs to be created. um, so you need to be able to define law reform, and all four reasons for law reform you need to know and be able to give examples and describe. So there was also reasons for law reform. Why are they changing? Why are the laws changing? And these are ways that the public can influence a change in the law by petitions or demonstrations, and then court cases. So how do the people influence law reform? In terms of petitions, these are simply formal or written requests to Parliament to take action in relation to a law in need of reform. It could be in paper form or it could be electronic. That's getting obviously more popular. So you've all heard of petitions. They're trying to get a bunch of people to sign for that change and therefore to influence the reform to happen. What's great about it in terms of strengths? It's very simple, easy, not expensive. We can get lots and lots of votes for law reform very, very quickly. Um, and another strength is if the petition reaches Parliament and is given to Parliament, they have to present or table the petition in Parliament. And they will unavoidably see it and have to think about it and consider a potential law reform or change to the law. Some weaknesses are that Parliament receives hundreds, if not thousands, of these, and they have also no obligation to implement the law reform. So they might even not know about the petition because there's too many, and they might just not want to go through with it, and they don't have to. Similarly, the influence of the success of the petition could also depend on who tables it in Parliament. Um, Next, we have demonstrations. This is where a group or groups of people come together to express dissatisfaction with laws. It can be an effective method of alerting the government to the need for laws to change. So you see demonstrations happening in public where a group of people comes together and almost like a semi-protest, but a protest is like the more potentially drastic version, can be a more drastic version of that. But this is what happens in demonstrations as a weakness. They can turn violent. This is obviously a bad thing, and it makes them ineffective. Parliament is not likely to take it seriously if people are violent or seem crazy and very irrational. It can also be hard to plan or organize. Many people may not show up, and it could be impacted by factors such as weather. So it's difficult to get a lot of people in one place, and you do need a lot of people in one place for this to be effective. And in terms of strengths, popular demonstrations can attract lots of media attention, making sure this gets to politicians, and it can raise social awareness and spark even more debate and discussion in society and trying to implement law reform. Um, Lastly, we have court cases, of course, because people can take cases to court to try to spark change via common precedent if there is no existing law or in that area, or they could try to even see what the judge can do. They might even try to get the judge to comment, make some obiter dicta comments, or if it's unfair or unconstitutional. So, what are some strengths? They can clarify legislation that isn't clear and expand or restrict its scope of operation, and that can be in favor of the individual trying to influence law reform. Judges are, of course, politically independent, so they will make rulings on the law rather than political pressure. And similarly, we need standing as a disadvantage, we need time and cost, um, and the judges will only be able to make any interpretation or change if the case comes before them. So, lastly, you need to know about the role of the media, and this is broken down into traditional and social media. Traditional media include your outlets like newspapers, TV, and radio, things that have been around for a long time. And these can be used to spread political information, examine, discuss, and inform people about legal issues and also law changes. This is the mode of media that reaches the most amount of people and reaches to even very young populations and very old populations, likely, particularly television. Then the role of social media, such as your internet tools and platforms, and you can't define it just saying social media. But it is more intended to communicate information, comments, and opinions. It can connect people, including governments and politicians, and inform them on a range of legal and global issues. It can have a really wide reach, and it can spark debates and conversations in society. And that can be used to try to influence law reform and raise social awareness. Lastly, have a look at the VLRC. It's an independent government funded organization that you will study, and they monitor and essentially coordinate law reform activity in Victoria and advise the government on ways to improve and update law. They're able to conduct comprehensive reviews into an area where potential law reform may be needed if the government initiates this. And they have direct connections to Parliament through the Attorney General. Their reports will all be tabled in Parliament and will be reviewed by Parliament, but the Parliament does not have to follow the recommendations. They have no obligation. So, but they're also government funding, which there is a consideration that this is a government agenda. They can pretend that they care about an issue and investigate it, but really they don't care, and they're just funding VLRC to investigate, to appear like they're caring or trying to do something. Unfortunately, in terms of Parliament responding to law reform, they can do this pretty well because the key points you need to know and you will study later in the year in more detail. They are elected and the supreme lawmaking body. We discussed this, directly chosen by the people, have more power compared to the courts, quite literally in most cases. Parliament can investigate the need for law reform, such as through VLRCs, and Parliament can respond quickly to a need for legislation. In terms of courts responding to law reform, judges can make decisions without political pressures because they are independent from Parliament, and we know judicial power is kept separate from administrative and legislative, for the most part, in theory. They can declare legislation ultra vires in the High Court beyond powers of the Commonwealth Parliament if it breaches the Constitution, or the lawmaking powers of goes outside the lawmaking powers of the Commonwealth. And they can also highlight problems and raise awareness. They can point out things that are wrong in their obiter dicta, comments made by the way as part of a court case, and try to raise awareness and get the Parliament to notice and the public to take notice of that. Okay, so that's all from me. Congratulations on getting through of legal studies for this legal studies units 3 and 4 lecture. I hope you found that very helpful, and it's really helping you consolidate and also get a head start on unit 4. Thank you so much, everyone, for watching, and best of luck with legal studies and the upcoming exam. Thank you, everyone.